Well, I just want to make it known to the court in order for me to proceed. I first require the court to recognize I'm here in a special appearance as a
Okay, I'm
beneficial.
not going to do that, Miss Alexander. Um, Miss Alexander, you're either here or you're not here. So
Are-
I'm not,
So, so I can't proceed until the court recognizes my right of subrogation
okay.
and the plaintiff's certificate that the right to please take the notice of the bill of complaint that was filed.
Miss Alexander, I looked over what you filed. Are you a minor? Are you under 18 years old?
That's not again.
I
I
asked
have
you a question, Miss Alexander. I'm not going to do this with you. Are you under 18 years old, Miss Alexander?
I cannot proceed
Okay. Then we
until
will,
this court
if you're not
recognizes
here,
my right.
if you're not going to tell me
I
that you're here,
cannot
okay.
proceed until the.
I'm going to talk now and you're not going to interrupt me. So I put you on mute. Miss Alexander, if you are not here, then there is going to be a default order entered. I am not going to play games with you today. I asked you a question. If you are under 18 years old because you filed a bunch of documents saying stuff about being a minor, that is my question to you. I'm not going to recognize you as a special representative. You're either here or you're not here. We don't have, if you're an attorney representing somebody, then we will do that. But other people don't lay people do not represent lay people. So you're either here or you're not here. Okay. So I'm going to unmute you and you can let me know the answers to my questions.
I'm here as the title holder of my birth certificate. I have my birth certificate right here.
Miss Alexander, how old are you?
Again, I'm here as the beneficial, equitable title holder of this birth certificate.
Miss Alexander, how old are you?
So are you not going to recognize my rights?
How old are you, Miss Alexander?
Are you not going to recognize my
Okay.
rights in this proceeding?
You can put Miss Alexander in the waiting room for a few minutes. We'll bring her back out when she's ready to. All right. Put her in the waiting room, Miss. Miss Rodriguez, please. All right. All right, Miss Alexander, we're going to try this again, okay? I'm trying to find out if Marquetta Alexander is here. If not, then it's a default situation, okay? So that's what I'm trying to figure out. If you want to unmute and answer my question.
Your Honor, your question was my age and whether or not my complaint that I filed is saying that that I was underage, and that's not what that complaint says. It clearly states that I said that I am not a minor and I'm not an infant.
Oh, it
And the
says on the
reason,
very first page of your complaint or your answer, Marquetta Alexander, comma, infant slash minor. So that's why I asked
and
the question.
and
So you're
if you and
okay.
if
So
you
Miss
look at,
Alexander, here's the thing.
ma'am,
Okay. Here's the thing. I want you to answer my question. Are you a minor?
ma'am, I never said I was a minor.
So what's the answer to my question?
I'm not a minor.
Okay. So thank you. All right. So Miss Alexander, you are here today. Is that correct?
I'm here
Okay.
as the beneficial, equitable title holder of the certificate that I showed you for the reason that it's a frivolous dispossessory because it's on a business and that is an individual. The contract has never been contracted with the individual. There is no
Okay.
social.
All right. We're not jumping into a trial right now. As I said at the beginning, everybody is going to have a conversation to see if you all can reach an agreement. So I'm going to put you all in a breakout room. If we need to set it for a trial, we'll set it for a trial, and everyone can put their
Can I have a
exhibit
witness?
in. Excuse me. Do not interrupt me while I'm talking.
I'm sorry.
If we need to have a trial, we will have a trial, and everyone can put in their exhibits and their leases and everything. Okay. But I'm not going to say anything else right now. Let's put them, Miss Alexander and Miss Bofield, in a breakout room to see, is your witness, Miss Bofield, do you have a witness here?
Yes, Your Honor, Ms. Hunt.
All right, we'll put those three in a breakout room and see if you all can reach an agreement. If not, just come on out. Oh, you can proceed, Miss Bofield.
Yes, Your Honor. So we have entered into a pay and stay arrangement. The amount that will be paid is $4,820.47, which represents rent from November through March. It needs to be paid by March 11th to the landlord in certified funds by 5 p.m.
Okay.
If that is paid, then of course the tenant is allowed to stay. We will dismiss the action. If it is not paid, then we will be seeking a writ and a judgment for that same amount.
And Miss Bofield, is the judgment, does that, I'm sorry, did you say that's all of rent for March?
Yes, Your Honor, that is the complete monthly rent for March.
So if that payment is missed, wouldn't the judgment be reduced to
It would
the,
be reduced until the 7th. Yes, Your Honor. So that's
to the 11th, you mean?
to the 11th. I'm so sorry. Yes. So it would be reduced. Let's see. It would be reduced to $4,391.76.
Okay, thank you for doing that adjustment. All right, Miss Alexander, if you will unmute and raise your right hand for me, please. Do you swear from the testimony you're about to give in this matter will be true and correct under penalty of perjury?
Yes.
Thank you, Miss Alexander. You can lower your hand. I'm going to go over the terms with you to make sure that's what you agreed to. So you all came to a pay and stay agreement. Is that correct?
Yes.
Okay. Did you agree that if you pay $4,820.47 by 5 p.m. on March 11th, 2024, that you would be able to remain in the property and they would dismiss the case?
Well, yeah, I did, but I would like to agree to the new amount.
Okay, well,
just as
I'll explain it in a second.
Okay. Okay.
That
yes,
amount,
I agreed to that. Yes, I agreed.
Yeah,
to
that's the amount that includes.
I agreed. Yes.
Okay, so what I was
Yes.
saying is, and then if you miss the payment, they would get an immediate writ of possession and a judgment for the amount, but only through that date.
Okay, I understand.
And
yes.
that amount would be $4,391.76.
Yes.
Okay, was that your agreement?
I agree. Yes.
Okay. All right, Miss Alexander. Good luck to you. You are excused from court. I hope that pay and stay works for you. And Miss Bofield, if you can send in that proposed order, we will then, after I sign it, it will be emailed to both of you. All right.
Yes, Your Honor. Thank you.
All right. Everyone on this case is excused. Thank you very much.
Thank you, Your Honor.
Thank you.
All right.
Ms. Meyer, what time did you show up for court today?
Like 9:02.
Say that again?
Like 9:02, I barely made it.
She's been here this whole time, Deputy?
Yes, she's been here.
All right. Mr. Patterson, how does your client wish to proceed?
Your Honor, I would announce at this time pursuant to plea negotiations in 23 CR 3058, she is going to enter a plea of guilty to interference as well as possession of paraphernalia. States agreed to dismiss count 3, disorderly conduct, as well as dismiss 22 TR 4156.
Okay, dismiss the 4156 entirely, with or without?
With, Your Honor.
Okay. And then on the other case, guilty to count 1, interference, and count 2, para, is that right?
Yes, Your Honor.
Dismissed any remaining counts. Okay. So Ms. Meyer, is that your plea agreement?
Yes, ma'am.
How do you plead then in 23 CR 300058 to count 1, interference with law enforcement?
Guilty.
Is anyone making you enter this plea of guilty by any threats or promises?
No, ma'am.
plead in count 2, possession of paraphernalia? How do you plead it? Do you plead guilty in both counts, interference and possession of paraphernalia? You understand, if I accept your pleas, there'll be no trial. You'll be found guilty and unable to appeal the conviction.
Yes, ma'am.
All right. So what happened on December 4th, 2023 that, in your own words, would make you guilty of interference with a law enforcement officer?
I refuse to be arrested.
You refused to be arrested? What behavior did you have as you refused?
Used my First, Fourth, Fifth, and 11th Amendment.
I'm having a little bit of a hard time hearing you. Can you say that again, please?
I just applied like amendments. I walked away, really. That's all that I did, and continued about my day. Like I went to the bank.
So you said you used your 3rd and 4th amendments?
The First, Fourth, Fifth, and 11th Amendment. Yeah.
Which amendments are those that you're referring to?
I'm unsure.
And Judge, if I may help, I would tell a court that as a factual basis, what she would tell the court is that the police officers had directed her to turn around, place her hands behind her back, and that she was being placed under arrest, that she did not physically follow along with their directions and in fact was resisting some, so that that would qualify as the interference that she's pleading guilty to.
Very good, but I want to know what her understanding of these amendments are as to what she did when she.
My rights as an American to be free.
Okay, what you said you applied your 3rd amendment. What did you do?
No, my First, Fourth, Fifth, and 11th Amendment.
1st, 4th?
That's all that I said. I said I'm applying my First, my Fourth, Fifth, and 11th Amendment.
Okay, and what's
Like my rights to be free.
what's the 1st amendment that you're citing? Can you tell me what it is?
No, I cannot. I have it written down somewhere in a notebook. I know I had my
Okay,
notebook
so
on
you
me.
don't know what the
I
First
was
Amendment
ready.
is?
Not off the top of my head,
And
but I have it in a notebook that I had on me that day, and I was ready to read them to him. He said I was being arrested for disorderly conduct.
what's the 4th Amendment, if you know?
It's in my notebook, ma'am. I'm
Fifth?
not
You know the
educated.
5th?
I
You know the
Googled,
5th?
ma'am.
Do you know the 5th Amendment that you used?
I know that I have it written down and I had them prepared to state to him.
All right, so I presume you don't know the 11th Amendment either. Do you? Can you tell me what the 11th Amendment is that you were using on the officer that day?
My rights as an American to be free and freedom of speech. I know that they all have.
That's the
something.
11th Amendment?
Pretty sure it actually has something to do with like my rights to be a parent.
To be a what?
To be a parent, like it has something to do with like my parental rights.
Okay, all right. So you had you think you had these amendments written in a notebook and you
I
were
have them
going
written
to
in a
read them
notebook.
to him, but you were going to read them to the officer, but you didn't?
He didn't give me a chance. It was him and like 2 other officers that came and
So
put
as
me
you're,
on the ground because
as
I
you-
walked away because he did not have any reason to necessarily arrest me. He drove past me and then did a U-turn and then blocked me off to go to the bank.
okay. So do you agree that you did what your attorney said you did?
Yep. Yep.
Okay.
I'm guilty.
Okay. And did you have some drug paraphernalia at the time?
Yes, I did.
What'd you have?
I am unsure what they found in my bag, but I know that I had paraphernalia on me.
These were items you were going to use to ingest or inhale some illegal substances?
It was like at the bottom of my bag. I was not high the day that they arrested me.
Okay.
Glass pipe, Your Honor.
Well, oh, a glass pipe. Okay.
Yes.
A pipe that you'd use to smoke what? Marijuana, meth,
I don't know.
some kind of illegal drug?
Yep, some sort of illegal drug.
Okay. Controlled substance. All right. I'll accept the pleas and find you guilty, dismiss the remaining disorderly count and the other case. Recommendations for sentencing?
In count one, the state would recommend a fine of $100, a 6-month underlying suspended for a 12-month non-reporting probation. And in count two, a $50 fine, 30-day underlying to be run concurrent to count one, suspended for a 12-month non-reporting, as well as any cost or fees.
Anything further, Mr. Patterson?
No, Your Honor.
All right, so Ms. Meyer, where do you work?
I'm working for,
Okay,
we set up outside of like Lowe's and like Outwoods and stuff like that.
sure. And is this like 40 hours a week, full-time?
I would say more like 30, like a part-time.
Okay. I am going to waive attorney fees, but on count one, the interference, your fine is $100 and your sentence is 6 months in the county jail, but I will suspend that. Count two, the drug paraphernalia will be a $50 fine, a concurrent 30-day jail sentence, suspended. You will pay $158 in court costs and $60 supervision fee. You will be on a reporting 12-month probation. Call court services or go by there as soon as this hearing is over, although they're probably closed until 1 or 1:30. But you must report to them today. I'm ordering all standard conditions of probation. I wish you success on this case. Please do what you're told so you don't have to come back and see me again.
Yes, ma'am. Thank
All
you.
right, thank you. You're free to go, and as we are in recess.
This case demonstrates a recurring misunderstanding in sovereign citizen arguments, the belief that personal legal interpretations can override established court procedure. The defendant attempted to introduce non-recognized concepts such as equitable title ownership and special appearance in an effort to avoid standard jurisdictional questioning. However, courts operate under strict procedural rules. Before any argument is heard, the judge must confirm identity, jurisdiction, and legal participation. When a party refuses to answer basic questions, the court is required to maintain order and may impose procedural consequences, such as default warnings or limiting participation. The judge's responses reflect standard judicial authority, not personal conflict. The goal is always to ensure the case proceeds fairly and efficiently under established law. Sovereign citizen defenses consistently fail because they are not recognized legal doctrines. They rely on misread constitutional language and internet interpretations that have no standing in real courts. The key takeaway is simple. Courtroom outcomes are determined by lawful procedure, not personal legal theories. When defendants refuse to engage with that process, the court does not stop. It proceeds without them.